There are a lot of ways you can prove someone wasn't too drunk to consent to sex. The trick is, the question isn't whether somebody was drunk when they were having sex, it's whether they were incapacitated. And every school defines incapacitation a little bit differently, but generally it means that the complainant was so drunk that she couldn't understand the who, what, when, and where of the sexual activity that was occurring. This is an issue that comes up in the majority of our cases, and there are a myriad of ways that we can prove a complainant wasn't actually too drunk to consent to the sex. We'll often pull the surveillance footage from the complainant's dorm to show that on the night of this incident, she swiped into her dorm and walked up to her room without having any issues with mobility. If somebody's dorm doesn't have surveillance footage, you can just take pictures of the 3 flights of stairs, for instance, that she would have had to walk up to get to your room to show the same point that she wasn't having issues with her mobility. We'll also often submit an actual picture of a map showing that the 2 of you walked from the party to the dorm and it was a half a mile in the dark. And you can even just point to facts that you learned about the complainant, things that you wouldn't have known unless she told you, to show that she was having a coherent conversation with you. So for instance, you can point out the fact that she told you where she's from, what her parents do for a living, or even what type of birth control she's on. And so while the issue of incapacitation comes up in the vast majority of sexual misconduct cases, it's not actually that hard to prove that a complainant wasn't incapacitated.